Welcome to the Contract Law Lecture Series at the University of the West Indies Faculty of Law at Cave Hill. I'm Mahncke, and today's lecture is on consideration. Let us begin by taking a look at an overview of today's lecture. First of all, I'll give a brief introduction to the area of consideration. We then look at the three pertinent questions that we ask when we're faced with the topic of consideration. First of all, what is it? Secondly, how do we measure it? And thirdly, when is it sufficient? We'll then look at some specialized rules that relate to consideration. Past consideration, the rule that consideration must move from the promisee, rules relating to existing contractual duties, public duties, and legal duties, the rules relating to part payment, and lastly, the rules relating to promissory estoppel. And at the end of the lecture, I'll provide a brief summary. When we learn about consideration, figuring out what it is, and in particular, why we have it in the first place, it's worthwhile taking a look at history. Indeed, we'll find that in the early part of the common law, first few hundred years or so, there was no contract law. Any claims brought that were contractual in nature, the courts would not hear because the courts would say, these are private parties, they make promises to each other. This is not for the courts. The parties themselves have to resolve these issues. However, it was possible to bring claims in tort, specifically in trespass and in deceit. So the argument would run along the lines of a party had made a promise and not kept the promise, and that was deceptive. There was deceit. And the courts would sometimes hear these cases, in particular when it came to debts. Now, from this, the claim of a sumsit was developed. A sumsit basically means that someone has undertaken something. So the sumsit claim is really the first type of contractual claim that the courts regularly heard. And from this developed what we know today as our contract law, what we're learning about. Now, the fact that courts in the early years of the common law wouldn't hear cases at all because they thought these were private matters helps to explain why even today courts will only hear cases based on contract law where both parties have provided something as part of the bargain. Hence, we talk about contracts as being bargains. So not all claims will be upheld. If there is a gratuitous promise, that means a party made a promise which is gratuitous, which was not reciprocated in any way, the courts will not hear such a claim. So only promises that are part of a bargain result in valid contracts. That means something must flow in both directions. Someone must make a promise and the other person must give something in return. And that what is given in return is called consideration. So we then ask ourselves, what is it that we need to give in return in order to form a valid contract? The case of Curry and Misa is indicative, where the judges laid out the definition of consideration as follows. A valuable consideration in the sense of the law may consist either in some right, interest, profit, or benefit accruing to the one party or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other. It is enough that something is promised, done, forborne, or suffered by the party to whom the promise is made as consideration for the promise made to him. So we see that consideration may be viewed very broadly. It could be any number of things as listed here, a right, an interest, a profit, or even a forbearance, a detriment, a loss, and so on. We also see that the term in the sense of the law is used. Now, as we shall see, this is important. Now, this is important precisely because what we may find is something of value may not be the same as what the law considers to be something of value. When we use the term something of value in an everyday context, we might mean something that is good value. Or we might mean something that we really like. Or we might mean something that is very useful to us. But the law may not see it quite the same way. In Thomas and Thomas, the court said the following. For a promise to be enforceable, something of value in the eyes of the law must move from the promisee to the promisor. Now, we'll come back to Thomas and Thomas in a moment, but for now, let's focus on those words, something of value in the eyes of the law. So again, a distinction is being made between consideration as something of value in the eyes of the law on the one hand, and something of value generally on the other hand. In Chappell and Nestle, which is another case we'll return to in a few moments, the court said the following: a contracting party can stipulate for what consideration he chooses. A peppercorn does not cease to be good consideration if it is established that the promisee does not like pepper and will throw away the corn. So this really expresses the idea that something of value doesn't necessarily have to be something that we like or that we find useful. What matters is what the parties agreed. And the first sentence here, a contracting party can stipulate for what consideration he chooses, really goes back to the whole notion of freedom to contract. It's up to parties to decide whatever they want in respect of their contract. The courts will only look at whether there is consideration. So even a peppercorn could be good consideration, irrespective of the fact that the promisee may not like pepper. Now, we've established that consideration is something of value in the eyes of the law, and something of value in the eyes of the law may be slightly different from something of value in an everyday sense. Now, having established that, we may ask ourselves, does something of value in the eyes of the law need to be tangible? Must it be something like money, or as we saw in Chappell and Nestle, a peppercorn, something tangible? Well, the answer is no, it doesn't need to be tangible. So for instance, when we look at Bainbridge and Firmston, we find that missing out on something, forbearance, may also be valid consideration. What happened in this case is that Bainbridge owned some boilers, and you see an example there in the picture. So these are big, massive boilers used for steam machines. And Firmston wanted to have some of those boilers, to take them and weigh them, and then he was going to return them in good condition. So Firmston's promise was that if he could have those boilers so that he could weigh them, he would return them in good condition. Now he took them apart, weighed them, and then he brought them back, but he didn't reassemble them. So they did not come back in good condition as had been promised. And Bainbridge said, well, you promised that you would return them in good condition. Firmston said, well, I may have promised that, but you did not provide consideration. So Firmston was basically arguing that there was no valid contract because there was no consideration. And here's what the court said. The consideration is that the plaintiff, at the defendant's request, consented to allow the defendant to weigh the boilers. I suppose the defendant thought he had some benefit. At any rate, there is a detriment to the plaintiff from his parting with the possession of for even so short a time. So, the mere fact that Bainbridge did not have the boilers for the period of time while they were in Firmston's possession, in and of itself is consideration, because that is forbearance. That is a detriment not having them. So that too can be consideration. Now, before we move on to how we measure consideration, let us briefly look at what we know so far. We know that consideration is something of value in the eyes of the law. Now, normally there are both benefits and detriments on both sides for both parties. So for instance, look at the usual kind of buying and selling scenario. You go to a shop and buy a bottle of water. Now, after you leave the shop, there's a detriment to you, which is that you have less money in your wallet. There's also a benefit, which is now you have a bottle of water which you did not have before. And it's the exact opposite for the shop. They no longer have a bottle of water on their shelves, but they have more money in the cash register. So both benefits and detriments on both sides. But as we saw in Bainbridge and Firmston, it is sufficient for the purposes of finding consideration to identify the detriment. That's sufficient. Now, why is that? Well, I would argue that even in Bainbridge and Firmston, there was both a benefit and a detriment on both sides. You may ask, what's the benefit to Firmston to pick up the boilers? Well, that's really for Firmston to figure out what their benefit is. What about Bainbridge's benefit in letting Firmston have the boilers? Who knows? Again, he must have seen some sort of benefit in going through with that transaction. But the court looks at the detriment, and in this case, of course, the detriment was that Bainbridge did not have the boilers for a short period of time, and that in and of itself is good consideration. We should also mention that consideration can be executory or executed. So if you come across those words, that just means that some contracts are ongoing and some contracts are performed immediately. So the one when you go to the shop and buy the bottle of water, that contract is executed. You hand over the money and you get the bottle of water, it's done. And an executory contract is one that is still ongoing. For instance, a rental agreement. So you haven't rented the property yet, or you are still renting it and some of the rent hasn't been paid yet because you haven't gone into the next month. So it's an ongoing arrangement, hence it's executory. Now, moving on to measuring consideration. The rule is that consideration must be something of economic value. Now, moving on to measuring consideration. The rule is that consideration must be something of economic value. Another way of putting it is that it must be measurable in monetary terms. And I think when we looked at the obiter in Chapel some moments ago, we saw that the judges expressed that even a peppercorn could be good consideration. Now, of course, a peppercorn is worth next to nothing, but it is still worth something. Hence, it is something that is measurable in monetary terms. Now, in fact, the case of Chapel and Nestle was not about peppercorns at all. That was simply an obiter. What the case was about was, it was about a special promotion which Nestle was running, whereby if you bought 3 of their chocolates and kept the wrappers and sent in the wrappers with a small amount of money, let's say 1 dime, I think it was 1 dime or so. So if you sent in the 3 wrappers and that small amount of money, they would send you a record, and the rights to the music on that record belonged to a company called Chapel. Now, under the laws relating to royalties, what would normally happen is that Nestle would have to pay 6.25% of the value of those records to Chapel as the royalty in that case. Now, the way that Nestle calculated that royalty was to take the amount of money sent in by the customers, who had also sent in the 3 chocolate wrappers, and calculated 6.25% of that as being the royalties. And Chapel disagreed. Chapel felt that the royalties should be valued not only by way of the actual money sent in by the customers, but also on the basis of the 3 chocolate wrappers. So in essence, they were arguing that the 3 chocolate wrappers had an economic value. And of course, that is exactly what we're talking about here. Whether or not something as mundane as a chocolate wrapper, something that you would usually just throw away, has an economic value, whether that is measurable in monetary terms. And the court agreed that it was. So the chocolate wrappers were deemed to have an economic value, and so even a chocolate wrapper can be good consideration. And of course that makes sense, because if the customers had just sent in the dime but not the 3 chocolate wrappers, Nestle wouldn't have sent them a record. And of course Nestle, by running this promotion, sold more chocolates, or one would assume they did. So that's something that's good for them, and they make money from that. So even something as simple as a chocolate wrapper amounts to good consideration. Another case we can look at is Alliance Bank and Broom. In that case, Broom had borrowed money from the Alliance Bank, but that loan was unsecured, so Broom had not put down any form of deposit. And when Broom failed to pay back the loan, Alliance Bank asked for some sort of security, and Broom provided that. In exchange, Alliance Bank promised not to sue Broom for the outstanding loan. Now, what happened is that Alliance Bank went ahead and sued him anyway. And the argument in court came down to whether or not this agreement, so not the loan agreement, but the agreement not to sue in return for some form of security, was a contract. And the court said it was, because the Alliance Bank, by forbearing to sue, that in and of itself constituted consideration. And of course, on Broom's side, what he provided was the security. But if you're going to argue that there was forbearance to sue, you must demonstrate that that really was the case. And in Collins and Air Jamaica, Mr. Collins failed to do so. So what happened in Collins and Air Jamaica was that Collins was an employee of Air Jamaica who was let go. Now, after he was let go, he was still able to make use of discounted airfares, which Air Jamaica had offered to their staff, as well as their former staff who were able to take advantage of that. Now, at some point, Air Jamaica cut that benefit. And so Collins said that that benefit, namely the discounted air tickets, was part of a contract, namely the benefit in exchange for Collins' forbearance to sue. So in other words, Collins didn't sue Air Jamaica for the promise to provide him with cheap airfares. But he couldn't prove that he actually did that he actually did not sue because of that. So perhaps if he'd been able to show that he was just about to start legal action, if he could show that the necessary steps had been taken, but then the promise was made that he could have these discounted airfares, then perhaps he could have shown there was a contract. But in the event, he could not.